We are happy to have you here on this program, on this edition of our webinar. We are honored to have you join us for this important and timely conversation focusing on improving efficiency, collaboration, and service delivery within probate administration. Administrative delay in probate matters can be a serious challenge, and this actually prompted us to having this enlightenment. The title for today's webinar is The Role of Lawyers and Private Officers in Reducing Administrative Delay. We sincerely appreciate everyone taking the time to be with us, both in the studio and online. Before we continue, I will want to introduce the moderator of the day.
Silence.
And the moderator of today is no person other than the head of corporate services, corporate secretariat and probate services. And the person of Dupe Akambi. As I hand over the program to my honorable moderator. Good morning, madam.
Good morning, Aaron.
It's good
nice to be
you.
here once again.
Yes, I like your smile.
Good morning.
Yeah.
And good morning, viewers. Thank you so much for taking our time to join us on Freeze Webinar 7.0. It's a pleasure being here once again as your moderator. And it's our expectation and hope that it's going to be a very insightful episode for all the participants and attendees online. Welcome once again. As he said, my name is Modukola Akumbi, and I head the Company Secretary and Probate Services Department of First Registrars and Investor Services. It gives me great pleasure this morning to introduce to you our guest speaker for the day, Mr. Tajudeen Adegbenga Elias. He is the Chief Registrar, Lagos State Judiciary, Ikeja. He will be joining us virtually. However, we have also here Mr. Patrick Nwaka, Chief Magistrate, Lagos State Judiciary. Today's webinar addresses how lawyers and probate officers can reduce administrative delays and also prevent financial and emotional stress on families due to issues of probate and transmission activities. We are going to be focusing on speeding up asset distribution, ensuring accurate paperwork, the use of technology, navigating court backlogs, and managing contentious estates to prevent lengthy legal battles and to minimize tax penalties, if any. Our guest speaker for today, I'll just give you a brief introduction of him. Mr. Tajudeen Adegbenga Elias began his education at Ebenezer Church Primary School, Ibadan, and proceeded to Epe Grammar School, Epe. Thereafter, he went to Odo Obara High School, Epe, for his secondary education, and the School of Basic Studies, Ijebu Ode, for his A-levels. He earned his LLB degree from Lagos State University, Ojo, and later obtained his BL from the Nigerian Law School, Victoria Island, Lagos, after which he was called to bar in 1996. During his NYSC in Ogun State, he worked with the Ogun State Property and Investments Company in Abeokuta as a legal officer. In 1996, he joined the Chief Toye Koka, Ogbe Kene and Co. legal practitioners, and later Shola Idowu, San and Co. as legal counsel. In 1999, he joined the Lagos State Judiciary as a magistrate grade 2 rising to the rank of Chief Registrar in December 2024. He doubles as the Permanent Secretary and Chief Accounting Officer of the Lagos State Judiciary, as well as the Sheriff and Probate Registrar. He has attended several conferences, seminars, workshops, trainings, and courses, both locally and internationally. He is a devout Muslim who holds integrity as his core value. He believes in making a positive and lasting difference in whatever he does. Today, he will be sharing with us invaluable insights on our topic, drawing from his extensive expertise in legal and probate matters. Without further ado, please join me in welcoming virtually the Chief Registrar, Mr. Tajudeen Elias, to this auspicious webinar, the role of lawyers and probate officers in reducing administrative delays. Thank you so much. You're welcome, sir. I hope you can hear us, sir. I think he's having a bit of technical itch at his end. Hello? Can you confirm if you can hear us, sir? While we are waiting for Mr. Elias, Mr. Wanka, would you like to just tell us in brief, the role of lawyers and probate officers in the probate process itself? Yes. What role do lawyers and probate officers play in the entire probate ecosystem?
Thank you very much, ma'am, for inviting us to this full webinar 7.0 series. The role of lawyers and probate officers in the probate process cannot be overemphasized. Lawyers basically represent estates, that is, beneficiaries of deceased persons, be they testators and testatrices, that's those who died writing wills, or deceased persons, those who didn't write wills, in applying for either grant of probate or letters of administration. So they serve as an interface. Lawyers serve as an interface between beneficiaries of estates and the probate officers who, upon the filing of applications by lawyers, probate officers go ahead to process such applications and will lead to the issuance by the Chief Registrar, who is also the probate registrar, of grants of probate, letters of administration, basically.
Thank you so much. So in brief, lawyers have a very unique role in the whole process.
Yes, please.
So that, I would suppose, includes the procurement of letters of administration, interpreting the will that the deceased, may have left behind, if at all they leave a will behind.
Yes.
Now, in the case of a deceased that did not leave a will behind, that is, would you want to tell us the difference between a probate with will and that one without will, so that our viewers out there can understand the difference and when each is required?
Well, thank you for this question. Now, grants of probate are issued by the probate registrar in cases where persons who died may have written a will stating out how their properties, which we call estate, will be administered. And in the will, they would most likely, in most cases, they will name individuals that they have appointed to manage their estates. These individuals appointed are known as executors for male, where they are males, and where they are females, they are known as executrices. Basically, when a testator, someone who wrote a will, has mentioned individuals who will manage his or her estate. When the person now dies, they would approach the probate registry for the issuance of grant of probate. That is because in this case, the deceased person has specified those chosen by him or her to manage his or her assets. And the probate registry, in the course of processing the application, would comply largely with the requirements and instructions of the deceased person by listing those individuals, save in certain instances, or one of which, if the person chosen has died, that person can no longer be granted power to administer the estate as an executor, or where the executor declines acting as an executor. Maybe has gone to court to apply to court that he should be excluded from the process, and the court grants such an application. Those are instances where the probate registry may decline processing those individuals as executors. Now, on the other hand, there are cases where individuals have died without writing wills. Now, in this particular case, because they didn't write wills, the family and beneficiaries do not know who the person would have opted for to manage his or her assets. So in that case, the beneficiaries, or some of them, would approach the probate registrar applying to be appointed as administrators. That is, in this case, unlike the case of executors, who are appointed by the testator or testatrix, administrator is appointed by a court because the owner of the property has died and didn't appoint anyone to manage the assets. So they will approach the probate registry and the court will appoint a number of individuals, minimum of 2, maximum of 4, as administrators to manage the estate of the deceased person. Now, in this case, the process is somewhat different in the sense that when they are applied, though there are similarities, but certain distinct differences which I want to point out here. Now, where the estate or their lawyers apply for grant of letters of administration, that's in the case where the deceased person died without leaving a will, because of processing the application, because the probate registrar is not sure of whether the applicants are genuine beneficiaries or have been delegated by the estate, by the family, to apply for the application, we need to take certain safeguards to protect ourselves from liability in the event that in future it is found that the individuals who applied for letters of administration did so fraudulently. So when they apply for letters of administration, we require them to furnish us with sureties, like who stand like as guarantors to the probate registrar, so that in the event that it is found out later that those people who applied for the letters of administration and obtained it were not authorized by the family to do so, the sureties will be called upon. Whatever expenses they have incurred in terms of depleting the resources of the estate, the probate registrar will call on the sureties to reimburse the estate for the amount that has been depleted by the persons who ought not to have been made as administrators. That's one safeguard we take. Another safeguard we take is in the course of processing the application, after interviewing the sureties and finding them suitable, we'll now do what we call newspaper publication. It's similar to what obtains in the church, where people want to marry and they do banns of marriage. The essence of this is to give notice to the whole world, informing the whole world that certain persons have applied for grant of letters of administration over a person's estate. If anybody wishes to object to the application, you have 21 days after this publication to notify the probate registrar. That is the second safeguard we put in place. And where in the course of time, where some beneficiaries who smell foul play in the application get wind of this notification, they approach us and file what we call caveats. Caveats are objections to the process that was telling us to discontinue or hold on to the application. So we take these steps so that in the event that in future, if after these steps are taken, there are no objections and we go ahead to issue the letters of administration, and in future, a beneficiary comes up and alleges foul play, and maybe seeks redress in court, we will have safeguards to show that we took steps to notify the public of this application, but you didn't take any step to inform us of your objection. And so we took it that there were no persons objecting to that, which was why we went ahead. So that's basically the difference.
Thank you so very much. Now, one thing, it gives us at this end a lot of concern, which we are going to talk about in the course of this webinar. I think at this point I can quickly ask, since we are on the subject of confirming authenticity of administrators and beneficiaries who approach the courts for grant of probate or grant or issuance of letters of administration. Now, assuming two families, obtain, or let me put it this way, sir, can two factions of the same family obtain letters of administration for the same estates?
You mean
Differently?
No.
Differently.
No.
Does it ever occur?
It is not practically possible for two factions of a family to obtain two different separate letters of administration. Even if one family obtains LA abroad, they cannot come to Nigeria and obtain an LA. What they will do is they apply for resealing. Resealing is a process whereby you extend the application of a letter of administration obtained abroad to apply within a jurisdiction. For instance, the deceased person has estates or assets in, let's say, in a foreign country, and upon his death, the wife applies and is granted letters of probate or letters of administration, and they want to come and manage, because that grant of probate would only give the executor or the administrator jurisdiction to manage the assets in that particular country where it was granted. Now, where the deceased person or testator has assets in other countries, you have to go and apply for resealing. Resealing means extending the application of that grant of probate or letters of administration in other jurisdictions. So the courts in the other jurisdiction would have to, upon application by the state, by the executor or administrator, would grant a resealing order, as extending the application of the probate
to the present jurisdiction. But in our own experience as registrars, we have had occasions where two factions of the same family obtain letters for administration, separate letters for administration, and bring them to us. These are not essays, these are things that we as registrars have experienced in our industry. So, and it gives us concern that we are faced with this kind of issue.
Basically, while I do not rule out that possibility, the position of the law is that where two factions of a cannot proceed issuing grants of probate, or where beneficiaries are having disputes with estates over the sharing formula. That is one very, very. Then another issue has to do with assets and valuation issues, particularly where a deceased person has large estates scattered all over the world. Difficulty in carrying out valuation of all these assets all over the world could also cause a delay. Moreover, we are only restricted to granting letters of administration of probate for assets within our jurisdiction. Because of the law, the court is called Lex Citus rule. The rule, that is the law where the court is located.
So I want to be clear on this, as I'm sure that our viewers will also want to be clear.
Yes.
Now you mentioned here is the issue of jurisdiction.
Yes.
So it is where the valuation of assets, as we know it, will occur only on assets that are located within the jurisdiction of the court.
I want to specify real assets, that is property.
Properties.
Because someone that has only money in the bank can possess it anywhere in the country.
Okay.
But when it has to do with real assets, landed property, you can only obtain letters of administration or grant of probate in the high court in the state where that property is located. That's what it's called Lex Citus rule. So where someone has, let's just assume the man is very, very wealthy, has property scattered all over the world. Okay. If he decides to, if on his death, the family decides to apply for probate, letters of registration of his property in Lagos, they will list the property in Lagos. The High Court will grant, or fulfilling all conditions, grant them probate or letters of registration over the property here in Lagos.
Okay. For
them to have, instead of going, because in law, you can only issue one probate worldwide or one letter of administration. You cannot go to another state and obtain another one. Okay. What you now do is that you have to go to another state. Let's assume the man has property in Abuja. Okay. You go to the High Court in Abuja and apply to receive, for a receiving order, to reseal the grant of probate in Lagos, so that they will extend the application of that grant of probate to cover the man's property in Abuja. Same in all over the world, anywhere over the world. You have to go for resealing.
So that still brings us back to my earlier question. Yes. So having two LAs is an aberration.
Yes,
it's an aberration.
If at all it happens, the first in time prevails.
Okay.
Unless you can show the court.
Yes. People obtaining not once, not twice. So these things, we as the operator in this industry, we have seen a lot. Just playing the devil's advocate, where such occurs, that there are two letters of administration granted and using the law that you just cited, the first, and then we eventually discovered that first actually was obtained fraudulently. What happens?
In the hopes of the beneficiaries of the second one to go to court, to have the court now set aside that first one on grounds of fraud.
Okay. So also playing the devil's advocate, in case the LA has been processed and assets have been sold, what happens?
Yes, if the assets have been sold, they can still seek redress in court, asking the court for the relief of setting aside all the transactions that were carried out pursuant to the legally obtained estate. So anybody that buys estates under the properly obtained LA is
null and void.
It's null and void.
Wow.
No such is no risk. That is why it's always important, and it's quite common where you find that, from our experience, where parties are interested in buying property that belongs to deceased persons. Even when the family may have given them copies of the LA, they come to us to do due diligence. This LA genuine? Was it issued by Probate Registry? They come quietly without letting the family know what they are going to do. And it is to save their interest. It is meant to protect their interests, which is a smart move on their part.
So how can lawyers help in navigating a will that is ambiguous or has potential validity challenges?
That's a tough one. Well, to a large extent, that is why it is always advisable when lawyers are advising their clients on drafting wills, the language should be as simple as possible and avoid any form of ambiguity, so that anybody picking up the context of the will, picking in the will and reading it will see that it is written in plain language, it's unambiguous. Where there are issues of ambiguity, the family might have to resort to the court by way of filing and originating summons, have the court to interpret those ambiguous provisions of, because the essence of that is that the court would take into account what was the intention of the deceased in making that ambiguous clause and then interpreting it. And this one will also, that's why it's important, that's part of my recommendations, that it's important that solicitor should ensure the preparation of up-to-date wills, which clearly specify requests in simple and plain language, avoid ambiguity.
Okay. So, Mr. Adeoye, from the registrar's point of view, can you just let our viewers know some of the reasons that causes unnecessary and long delays in the transmission process? You know, the starting point is obtaining the letters of administration, but the letters of administration are not obtained in a vacuum. They are to an end, to the end that there will be proper transmission of the estate of the deceased to the beneficiaries. So, what could account for the long delays in the transmission process at the end, at the registrar's point of view, from the registrar's point of view?
Well, a lot create a delay in transmission process from registrar's, and I'm just going to talk one or two. The major delay always comes from incomplete. It has always been the issue, because sometimes administrators or executors, as the case may be, will drop documents that are incomplete. Some of the time, after dropping the document that are incomplete, of course, in those days we used to accept it when they will tell us, okay, we'll bring it some other. But now we do not accept it. So with that, to a large extent, we've been able to reduce, the delay in that area. Then, like my learned colleague said earlier on, another point is the issue of dispute in the family. We've had in our office here, we've had to engage families doing administrative mediation, just like your office. We've had to bring families together, see them down, talk to them, and all that. But, to a large extent, it could take several months in some cases to be able to resolve that. And that, creates delay. Then sometimes, some administrators will come with documents that are not genuine. We have seen several death certificates that are purportedly issued by National Population Commission that indeed, of course, we are on the face of it, you will know that this is not original. And a lot of, documents that even we as registrars cannot rely on. So all this, creates delay. Then another one again is our third party organization, like the banks and all that. So where we have, because part of the requirement is a banker's confirmation of signature, and where bankers of confirmation of signature is not, where the document cannot be, relied on by our process, it may create delay. There are some bankers' confirmation that even the banks will write to us that they didn't issue it. So on that, of course, the registrar will not be able to rely on such bankers' confirmation. And sometimes it takes eternity to get a confirmation of the banker's confirmation, so issued by these banks and all. So these and many more creates the delay. And of course, one of the reasons we are here today is to see how we could jointly see how we could, foster, provide a means of navigating through these delays and getting the job done in time and in good time.
Thank you. So I'm sure that our viewers they now have an insight into what causes bottleneck from the probate registry point of view and from the registrar's point of view. Incidentally, it's registrars, so there seems to be some similarities there. So, what are the strategies, Mr. Nwanka, that lawyers can use to deal with difficult or missing beneficiaries to keep the process flowing?
Now, what I would advise, when you say difficult, what do you mean by difficult beneficiaries?
Missing
beneficiaries
or difficult beneficiaries, in the sense that, okay, while you were talking earlier, you said some people may have been appointed as to represent the estate. They may refuse, they may say they are not interested.
Yes.
What are especially when we're talking about the grant of probate, the testator has appointed Mr. So and so as an executor.
Yes.
And this individual now comes and says, I'm not interested. And renounces
Yes.
it. No. So what are some of the strategies that you as a lawyer or as lawyers can use to deal with this difficult or in the situation where the particular executor may not even be within the jurisdiction?
Yes.
How do you address that
what
situation?
Happens is, for instance, where for grant of probate, where the testator has appointed 3 or 4 executors, maybe 2 may be out of the country. As at the time they are processing the grant of probate, they are unable to come to Nigeria. The probate registrar would now reserve power for them. That's the process called reserving power for them, by processing power to grant probate for the 2 who have come, because basically not just for them to appoint you as an executor. Okay. When you are appointed as an executor, and because there are certain processes. First of all, the testator have his will lodged in the probate registry. Then when the testator dies, the lawyer would approach the probate registrar to apply for a date for the reading of the will, indicating the number of beneficiaries, the particulars of beneficiaries that will attend the will reading ceremony. And the probate registrar will now issue letters of invitation to all those beneficiaries.
Okay.
Some could come physically, others could join virtually. Those ones who intend to join virtually would obtain in front of the chief judge for them to join virtually. Once that is done, letters have been issued, letters of invitation. On the date of the will reading ceremony, the will that is sealed, the ACRO would show to the beneficiaries, those attending physically, the will is sealed. They will seal the will in their presence from the envelope, bring out the will, then read the contents of the will, the hearing of all the beneficiaries, those present physically, virtually. After that is done, the next thing that the lawyer is supposed to do, like in case now, I'm just trying to explain the process. Okay. The lawyer should apply for CTCs of the read will for the beneficiaries, and then
so each beneficiary gets a copy.
Ideally, the lawyer should apply for each beneficiary to have a copy. Then, when that is done, the next thing will now be for the executors in the will to do what we call to the registry to indicate on oath that they are willing to. It's very important before we go ahead process. Now, for those who are unable to come, maybe because they're out of the country or health challenges, assuming there are 4 appointed executors and 2 can come, we'll go ahead after they've marked the will on record. The ones that cannot come, we will reserve power for them in the sense that when they come in future and go through the process, we'll admit power to them for probate. And then when that happens, we'll now have what we call double probate. So you have given probate first, the ones that first of all came, marked the will, and reserved for those who couldn't come. But when they come later, now admit them. After I've marked the will, now restore their power to them. Now, for cases where an executor renounces the will, assuming there are three executors, one has renounced the will, not going to act as an executor, the solicitor can approach the registry with, say, please proceed with the remaining three. And in the grant of probate, even though the will would have stated 4 executors, because we are giving power to 3, we have to indicate why we're not giving power to the fourth. So if you see some grant of probate, they will say, they will mention the 4 executors mentioned in the will. Power was given to 1, 2, 3. The fourth one was deceased, or the fourth one renounced. So I have to indicate the reason on the grant why we're not granting probate that fourth person.
So, Mr. Aaron, you have a question for our guest?
Yes, I have a question. Thank you, Mr. Mwap. I have this question. The question is, we all know that it is the High Court of every state that has jurisdiction over probate matters. In recent time, we have come to see, by reason of our operation that, letter of administration were issued by customary courts. What's your take on this?
Yes, I with respect to the reasoning behind the some customary courts issuing letters of administration over estates of certain deceased persons, I hold the respectful view it's misnomer, because the probate registrar is the chief executive officer of the probate registry, and he is the probate registrar of the High Court, Lagos State, not of the Magistrate Court, customary courts. Now, when applicants are applying for grants of probate and letters of administration, there's a stage, that is the penultimate stage, that is called minutes and order. The minutes is like a summary of the entire process from when they filed the application for grant of probate up until when they approach a probate judge of the High Court. It's a probate judge that will give that order, not customary court president. So it's that minute and order that, because if you notice on your grant of probate or letters of admission, they'll say there's a commencement date.
Yeah.
Okay. That is the date that the judge signed the minute and order. So it's only a High Court judge. That is an order
that
to
sign the
minutes and order. And it's that order that mandates the probate registrar to issue the grant of probate or letters of administration. So when someone comes to you with a court order or customary court
enrollment order,
enrolled order, my advice to you is to inform them to please go back to the probate registrar, High Court of the state, for them to get the documentation.
So an enrollment order, permit me please.
Yes.
An enrollment order is not a substitute for an LA or a grant of probate. It's not a substitute.
An enrollment, or if you see, like for instance now, the PT would, I didn't know which sort of question I have brought some. An enrollment order is an order from a judge of the High Court directing the probate registrar to take certain steps. You find that in all those enrollment orders you will see the applicants versus the probate registrar. They always see the probate registrar as a nominal defendant. And they will ask for reliefs. Basically, even for contentious cases, after they have asked the court for certain reliefs, maybe the court to list certain people as administrators for certain reasons, they also ask for an ancillary order for the judge to direct the probate registrar to remove those names from the LA or grant of probate. So
in layman's language, let me put it to you this way so that our viewers can better understand.
Yes.
The way I understand it.
Yes.
Me not being a lawyer,
yes,
So an enrollment order is actually an instruction from the judge of the High Court to the probate registrar to issue,
to do something. It could be to amend, because to amend to delist, or to add. Like there was one
amend, delist, or add.
For instance, you might have the initial. I'm sorry if I'm
Okay.
The initial LA may have appointed 4 persons. That is the minute and order that the judge signed, directing the probate registrar to appoint 4 persons as administrators.
Okay.
Now, because of over time, maybe 1 or 2, or 3 of them now have died. Okay. And then the lawyers of the estate would approach the court. Because, for instance, if they want to sell property and they bring an LA that contains the names of dead persons, if the interested buyer goes to do due diligence and find that those people are dead, they will think you are fraudulent.
That's right.
You want to sell property with individuals that are dead. So to avoid any form of foul play, when such people die, the estate is advised they should get a lawyer to approach the probate judge to delist the dead people and substitute them with other ones so that it can be going. Because if they go ahead and
act on that,
and someone comes to allege fraud, it will be difficult for them to excuse themselves, particularly when they knew at the time they sold, based on that earlier, that other administrators are no longer alive.
Yeah. So what we have experienced in time past is that some people bring in our list of requirements for transmission. We include LA, we include death certificate.
Yes.
But some people now bring an enrollment order, claiming that this is sufficient to act as an LA.
No.
So now, from what you have said, my understanding is that an LA cannot substitute.
An enrollment order
cannot substitute for an LA under any circumstance.
And I'll explain why. First and foremost, let us look at basic law. An order of court is binding on the parties that are before that court.
That's right.
Freeze is not the party before the court. So that enrolled order was not made against Freeze. So why should Freeze carry out the order of court?
That's correct.
That enrolled order is against the defendant named in that order. The defendant, their representatives, and others. Those are the people that the enrolled order is made against. And if you see an enrolled order that is not made against a probate registrar, be careful about that.
So the probate registrar is actually the defendant.
Yes,
always the nominal defendant in an enrollment.
And the enrolled order would direct the probate registrar to take steps with regards to the LA. So an enrolled order cannot take the place of an LA.
Exactly.
Under any guise. It is a judicial order of a high court directing the probate registrar to take steps, either to list dead administrators or executors, appointing new ones, because the court should have appointed new administrators, that it should list the dead ones and add new appointed ones to them, or to effect corrections. Maybe the LA has some errors. Maybe error in one of the alternate names of the deceased person. Any kind of error. If there's an error in an LA, they can't come and meet us and say, please alter it. It has to go back to a court. The court should now give an order to the probate registrar. That enrolled order directs the probate registrar to act according to the order. So an enrolled order is only a directive to the probate registrar. Simpliciter. It is not an LA. It can never be an LA.
Never. Okay, so before you please, because I want our viewers to be very clear on this, and there are reasons why we are asking these questions, because in our industry, it is something that happens from time to time, where people insist and challenge our reluctance to accept that in lieu of LA.
Yes.
Now, exploring this further, does the enrollment order, is it a directive to issue an LA? Can it be an order to issue an LA?
No. An enrolled order, because most of the time when you are applying for LA,
the reason why I'm asking is that some people will tell you, I have an enrollment order, my application is before the probate court to issue an LA, but because they are here to issue it, this suffices for you to act.
No, like I mentioned earlier, at the penultimate stage is what we call minutes and order. Now, the minutes and order, the minutes is a summary of the history of the application for LA. When they filed the application, because it will contain certain paragraphs. Application was filed, they've paid the estate fee, there's no caveats lodged, or caveat was lodged. The judge will see all those things and then approve. That date on the LA is the date the judge signed on the minute and order. Okay. So that minute and order is the directive to the probate registrar to issue an LA. nobody can go and get an enrolled order to a court to issue an early.
Wow. Okay.
That's
So
great.
it's the minutes and order.
The minutes and order.
That's great.
So the enrolled order is to take steps to alter
Address issues
in an early.
early.
Maybe to remove deceased or delist deceased administrators or executors, or to add other ones, or to effect corrections on an already existing early.
So when we as registrars are collecting
Receive
documentation,
and they give you that.
is it okay for us, for the applicants or for the beneficiaries to provide us with both the early and the enrollment order indicating that, or once the early has been
provided, it suffices.
the updated early has been provided, we don't need the enrollment
You don't need the
order
enrollment
at all.
order, but you need to do due diligence if that early is genuine or not, by writing to the
Probate office,
registry
yeah.
to decline because customary court is even beneath his jurisdiction.
Yeah.
So we have already excused them by saying, please, we need you to revert to the probate registrar of your state to give us the necessary documentation supporting this enrolled order. Don't tell them it is fake, we can't on it. Just say, okay, we have seen your enrolled order. However, for policy reasons, we require you to revert to the probate registrar of your state to give you an additional documentation you need from him to support it.
That's good. That's a good way.
That's great.
When they go there, they'll say, who gave this order? then you will now know that
It's not the right document.
Yes.
So, Mr.
But when you now engage them and telling them it is fake, you are agitating them, and they could be tempted to be difficult and lead to breaking of law. Not need to engage, just use civil and diplomatic ways to discharge them, so to speak.
Thank you so much for that.
Thank you really so much for that. My second question is,
Please.
in what circumstance will the probate registry in Lagos accept one administrator instead of two or more? In what circumstance?
This is an interesting question. I had an experience yesterday. There was an LA that was granted by the High Court of Lagos State in 1976, appointing 4 administrators. Now, over the course of the years, 3 of them died. Now, I don't know why the lawyer didn't apply to substitute the dead ones with new ones. He applied to the High Court for the High Court to allow the only one to
continue.
and the court granted it. We are bound to obey the court.
Right.
Bound to. When I saw it yesterday, I found it strange, but I said, well, it's a court order. I'm bound to obey it. That's the rare instance where we can only, because the court has directed us to delist the other 3 and let the sole existing
Continue
to manage the estate.
Okay. Now, where we have one executor,
Yes.
where we have one executor
Named
in the will, named in the will,
Yes.
definitely the probate registry should be able to grant probate.
We do.
on
We
one
do.
executor.
Yes, because that is the status instruction.
That's great.
Now, like, go back to the other one where I just mentioned the instance where the courts.
the others have died.
Yes. Why I believe the lawyer ought to have applied for substitution to get more is that, God forbid, that one
also dies.
They're in trouble.
So it's always better to have a backup.
So assuming they had applied to add 3 more, and one of the 4 die, you can just apply to court to the least dead one and continue with the 3.
Yeah.
And it's risky leaving to us one person. If that person dies, the state is expanded. You have to come and apply to court again to appoint another set of administrators. It will be cumbersome and delay. Cause delays.
All right, that's great. So the last question from me is that you rightly mentioned in your submission earlier on that the probate registry often requests for surety in case of fraudulent transaction. Yeah, is there a legal base for the requirement of surety in probate process, or is it just an administrative approach?
I didn't say it's a requirement of the law. I think I think there's one of the rules under Order 61 that requires sureties according to the legal state. I didn't say for fraudulent applications.
For all
I
applications.
said no applications for. Let us distinguish it now.
Okay.
For grant of probate, the testator has named I want A, B, C, D to manage my estate. We don't question that one. Okay. But for letters of administration where the deceased person didn't name anybody, that's right. Anybody can come from anywhere in the world and say, I'm a beneficiary, I want to manage. We don't know if, we don't know that person's locus as per the family. So we have to take precautions. In the event that if after tomorrow, after issuing the grant of LA, the real beneficiaries now come and say, this person is not part of us. Yeah. We have to take certain steps like disclaimers to show that we have acted with caution,
due diligence.
Yeah. So that in the event that is of, like that's why we ask for sureties. Sureties will indemnify the estate for any amount that has been dissipated by the later to be discovered fraudulent administration. Those who ought not have been granted early. Those sureties will now indemnify the estate.
All right.
In full value. And that's why we also require the process of newspaper publication. So we notify the whole world that so and so persons have come to apply for letters of administration. If anybody feels these persons are not eligible or objects to the process, kindly let us know. These are steps we are taking to show that if there's any tomorrow there's litigation, these are the steps we take to show that we try to do the needful by following due process, notifying the whole world and protecting ourselves against liability.
All right. The reason I asked that question is because several times we have had situation where, the wrong people will claim beneficiaries and approach us for transaction. So why I ask is we want to know if there are legal basis for requiring sureties so that we also apply that approach to safeguard our side.
No, the rules of court empower the probate registry to require sureties. So it's not for you to require sureties, so to speak, because for every LA that has been issued by a probate registrar, in most cases, they would have requested for sureties who would have been screened and approved. Those sureties would have undertaken on oath that in the event that the estate is dissipated by those who obtained the LA fraudulent, they will identify the estate in full value.
So I interpret that as you haven't done due diligence. That is, know your customer, KYC.
Yes.
Because from our own end, we have debates. We have had occasions where there are debates about LAs that we have received from people that are deemed suspicious. Now, and this always raises the question of, can we rely on this LA? Saying that the people presenting the LA appear to us to be suspicious, in quotes. Now, can we assume that the court, who is going to be liable if this LA turns out to be fraudulently obtained? So that always creates a question in our mind.
We even have cases where we have LAs
who is responsible to do due diligence to ensure that this LA is authentic, is legally obtained.
When they bring LAs to you, you are advised to do diligence by contacting the registry. It is not your fault. There's a case that we did that is ongoing. A deceased person had a daughter, only child. So the daughter and her husband applied for LA over her assets in Lagos, money in the bank, personal estates. Unknown to them, the woman's brothers in one other state, had applied for LA in that state. And incidentally, the woman has or held bank account with a particular bank. So normally, in the course of doing when they give you your bank certificate, you have to go to the bank, get information about the accounts, details of the deceased person and the account balance. Now, the one in Lagos, they already proceeded long ago. So when the
brothers
went to the same bank in one of the eastern states and wrote, the bank, of course, they did due diligence and found that somebody else has already approached us on a similar estate in Lagos State. So they wrote to us that they are unable to assist the applicants in another state. They want us to know that how can there be two different applications for LA for the same estate? So we're in the process of resolving it, but basically what I will inform them, because even when there are even in Lagos, there are times where you find two different applications on the same estate, because we have 5 divisions: Ikeja, Badagry, Ikorodu, Lagos, and Egbe. Some beneficiaries could come and file an application in Ikeja Probate. Others could go to Ikorodu and file on the same estate. Now, the good thing about it is that there's a point where they all converge. And one of them is where the estate has unit have treated the first one, and they bring the second one to flag. Treated this estate on a decline and send the file back, giving reasons cannot proceed because they have treated an earlier application for valuation from the Probate Registry Ikeja. In that case, we've had one case, my brother here and I. Somebody first applied in Lagos, they had hitches, abandoned it, able to file in Ikeja. At the point where they went to valuation declined our own because they said some years ago, they came to Lagos and we have done the valuation. What now happened, when such thing happens, because I said best in time prevails, that also applies here. Now sat down with my brother, HOD Probate Lagos, my sister, because there's no lady in the court.
I was going to ask that. I was going to ask you why you keep referring to your learned colleague as your learned brother, even though she's female.
Yes. So we sat down and did due diligence, and we found out that the application for LA in Lagos commenced some years before the Ikeja one. Wow. So the Lagos application took precedence. What do you call the lawyer? We now merge the file and give it to Lagos to continue. Because they cannot issue one probate anywhere in the world.
So that brings me to my next question as we round up, and this session has been quite enlightening. I'm sure that our viewers have, gained 1 or 2 insights into this topic. So, does the Nigerian judiciary have a centralized probate registry to synchronize all your activities such that anywhere in the country you can process your LA and be confident that the same process has not, been initiated in another state, to eliminate this issue of multiple applications or double issuance of the same of different LAs on the same estate. Because from your own side, from your angle, you may not experience it much, but we as the users of these issued LAs, we get double LAs from time to time issued for the same estate from different states, and is a cause for concern for us as operators.
At our own end, I would say with all sense of responsibility that I'm not aware of where there's a harmonized registry, the chance of LAs. And part of the reason is because of what I said, the lex situs rule. You're only limited to your territorial jurisdiction. You're not consider anything outside your territorial jurisdiction.
Good enough. That's been said. Good enough. Yes. We understand the issue of jurisdiction, no doubt.
Yes.
But also there is this in this age of technology,
Yes.
it is still one country, it is still
Yes.
one, nation.
Yes.
And let's look at other crimes.
Yes.
Yes, they all have their different jurisdictions.
Yes.
But look at the FBI, for example. The FBI has jurisdiction over the whole of the United States, even though each state has its own police. And when there are issues, specific crimes, the FBI steps in. Even if there are certain crimes that are under the jurisdiction of certain states, if it is beyond their capacity or ability to investigate or undo, they refer to the FBI and rely on the FBI's superior assets
Yes.
to solve those crimes. I would think that the Nigerian judiciary should, in 2026, in this day and age, have come to a level where you have a system that enables you to be able to have access to information anywhere in the country, any court in the country. That way, I believe a lot of problems will be solved, not just on probate issues, but other issues as well.
Well,
so that we don't have duplication of efforts.
I would defer to your argument to the point that maybe at the stage of making an inquiry, okay, I want to apply for LA for Mr. Balogun Adefemi
In Kano.
and I want to find out if a similar application has not been filed in, say, Oyo State. Maybe there should be a kind of synergy
Exactly.
where you can conduct
Exactly
just
what we are
research
talking about.
purposes,
Yes.
only
Yeah.
for research purposes,
For search.
because of the issue of jurisdiction.
Exactly.
There's a limit to what one can, because for purposes of search only. Maybe I agree. Maybe there may be need for all the probate registrars
to come together and think of how to,
so that to avoid multiple.
and then people that have dubious or this intention to game the system, because we know that there will always be people out there who want to game the system.
But even if some people find a way of undermining the system, once the LA has been obtained fraudulently and the real beneficiaries are aware, they have recourse to court.
They have recourse to court, but we all know that the judicial process can be lengthy, can be expensive, it can be tiresome, and it can be frustrating.
What some people do not realize is even in Lagos State today, there is an ADRO avenue. Even when they file cases in court, there's something we call CMC, Case Management Conference, where they sort out the issues. Okay, this case, to see where they could agree as to resolving certain disputes. And when those ones they seem to be agreeable, refer them to ADRO. The ones that are contentious, they refer them to litigation. So litigation is not the one-stop shop for all matters that have to do with the land Lagos. If they can, there's also avenues for mediation. Even though we do our own mediation at our own level, and even in courts, the court also has avenue for that, so that they can have issues resolved expeditiously.
Okay, so finally, as I know I said that before, but finally, is there a way that there can be a technological handshake between the probate courts, the high courts in Lagos, and us as registrars? And when I say as registrars, one, primarily as first registrars, technologically, such that we do not have to physically or manually send documents to you for confirmation through lawyers, so that there is a way we can access digitally and be able to confirm, as a company, and then as an industry, the registrars institute as a body.
Well, what I would suggest is that the registrars institute as a body, not just freeze, come together, do proposal to my lord the CJ, and the Lord approves of it. I don't see anything wrong with it.
Because that's going to ease the process.
It has to get the blessing and approval of the chief judge.
Okay, so that's something that we can explore. On this note, we would like to thank you so very much for being a part of today's webinar. It's been a very, very interesting topic, and I'm sure that everyone out there has gained one thing or the other and has learned one new thing or the other regarding the probate administration process from start to finish, the role that lawyers play in the issuance of grant of probate and letters of administration. We thank you so very much for being a part of today's webinar, and we look forward to seeing you next time. You can view this webinar on any of our social media handles displayed on the screen. We are First Registrars Nigeria Limited, and we are on Instagram, we are on Facebook, we are also on LinkedIn. Anytime you want to, we are also on YouTube. If you want to go back over this webinar, you can go to any of those social media handles, and I'm sure you it's going to be an educative process for you. Thank you so very much. We look forward to seeing you next time at our next webinar 8.0. God bless you, and thank you so much, Chief Magistrate Mr. Patrick Mwaka, for gracing this webinar.
My pleasure.
God bless you.
Thank you, ma'am.
We appreciate you.
Thank you, ma'am.